welcome back to our video series, Legalese Translator. My name is Heather Hui-Litwin, and joining me here today again is Heather Douglas. Hi.
Hi.
So in today's video, we're going to talk about actually two words, the word action and the word application. And in my trailer for this video series, I had mentioned that sometimes common English words actually have special meanings. And these words are some examples of that instance. So actually both of these words are referring to, they're kind of like the legalese for lawsuit, but there's actually they actually mean very different things. And so what I'm going to do today is I'm going to let Heather Douglas explain to us a little bit more about what the difference is between an action and an application. Heather?
Thank you. An action is a long road to get a judgment. It goes through many stages before you have a trial. First, you have to commence, so start the action through a statement of claim. And then you have to exchange pleadings. Then there's a discovery process. And then there are pre-trial procedures. And eventually, you make it to a trial. And the trial can take place 3, 4, maybe even 5 years after you start your lawsuit. For an application, it's commenced through a notice of application. And then you have an application record that has affidavits in them, all the relevant documents, factums, and that's served before the hearing date. And the judge looks at the application record for both sides, and then you have your hearing. There's no trial, there normally isn't any witnesses in person, and you get a judgment based on the written material. And the stages is usually you serve an application record, there might be cross-examinations, and then you have your hearing. So you can end up being before a judge on the issue within a month of starting your application. That would be rare to have it that fast, but it can almost be that quick.
Wow, so that's definitely an advantage, I guess, for someone to bring an application. Now, how does one know whether to bring an application versus an action? Like, shouldn't everybody kind of like just bring an application to begin with?
Exactly. So the rules, the default is usually in an action, okay, but there are certain matters that have to be brought through an application. So you would have to look at legislation depending on what kind of case you're bringing. Mm-hmm. And some types of proceedings, like some types of issues, they must be brought in an application. But usually cases are brought as actions.
So that's the default, right, you're saying?
Yeah, and also another way to think about it is an application is usually when you have an issue of law, and if you decide that issue of law, then the whole case kind of can be decided. But once you need to have facts that are in dispute, then judges tend to want to hear all the evidence and hear the parties in person. And that would make it less desirable to be an application. But if you're just looking for an interpretation of a contract or an interpretation of the law, and if that's decided, then it can decide the arguments between the parties, then an application can be brought.
Oh, that's really cool. And final question, let's say somebody started off in an application and they want to change their mind and they want to bring it to an action. Can they do that?
Yeah, the parties can switch it. Normally, you would bring a motion to the court and you would ask the judge to change the application to an action. Usually, you see them moving from application to an action, and that's generally because there are facts that are too disputed and you need to have a hearing and you need to have witnesses in person, and the judge wants to have a full evidentiary record as opposed to relying on affidavits in the application record.
Okay, that's great. Well, thanks very much, Heather, for clearing that up for us. And thank you for watching. Don't forget to subscribe, and we'll see you at the next video. Bye.
Bye, thanks.